Court calls the case, People versus Theophilus Smith.
Nicole Hughes on behalf of the people.
Edward Drukas on behalf of Theophilus Smith.
Mr. Smith, can you state your name, please?
Theophilus Smith. May I go in the breakout room with my attorney, Your Honor?
No.
Because I haven't.
Pardon?
Right off the bat, he asked the judge for something. The judge says, no.
This is what had happened was we're going to give our opinion on this video. I'm going to critique this video, this court case, the things you should and should not do in court. So that's what's going according to your Law and Order, CSI.
Hundreds of hours of Law and
expertise
Order watch.
and
Criminal Minds.
and my background of law enforcement. I know a couple of cops.
You do?
Yeah, I do. Yeah, I see one every day. Yeah.
Where you see them at?
Usually in the bathroom.
In the back?
Yeah, I look in the mirror.
Oh.
Yeah.
You have
So-
a police presence in the bathroom?
Yes, police presence in the bathroom at all times. So, yeah, so he's told no right here. This doesn't look good. They start off like this. Let's see how this works itself out. Welcome to what had happened was.
Because I wanted to change some things I wanted to do. Me and him talked briefly, but I didn't get down to the A's and B's.
You didn't get down to what?
I wasn't able to tell my attorney exactly what I wanted him to do for me today.
Mr. Drukas,
Thank you, Your Honor. Actually, I did spend about 50 minutes with him here this morning. I did get the discovery. There are some video that I did start to go over with him. We also discussed some potential other video that may still be outstanding. And again, I was appointed yesterday. I'm looking to get an adjournment today, so I can fully go over the discovery with him.
So the lawyer just got appointed the day before, and he just spoke to this person for about almost an hour right before they called the case. So he wants to get an adjournment, which means he wants to get a case postponed so that he can review the information that's presented before them, so he can present the case in the best possible light for his client. And the client is saying that he didn't get to talk to him enough. Well, the judge knows that he didn't get to talk to him enough because he wanted to make sure that it was on the record. The lawyer's trying to make sure it's on the record to say, I just got this case yesterday and I just spoke to the defendant today.
Right, and the attorney, no attorney, good attorney will want to sit there and go into any case unprepared, especially if I just got this yesterday and he's, as you see, he's not there. He's in jail.
He's already
So,
locked up.
He's already locked up. So this is something that, you want to make sure we get this right, because this could be someone's freedom at risk, permanently losing their freedom. You can't take the chance ever as an attorney of going into any case unprepared. That's just not good. It's not a good look at all. So normally the thing to do is a request an adjournment. Let's see how this works out.
And make a determination on what to do.
Probable cause conference in this matter,
What about
November 9th,
Did you
2023,
address bond?
9 a.m. Excuse me?
Can my attorney address my bond?
Well, he knows how to do that, but yeah, go ahead, Mr. Drukas.
Mr. Smith, I had gone over that with you. With regard to right now, we're not going to be addressing bond.
I didn't want to, that's why I wanted to go into the breakout room so we could be on the same page.
I know.
Your
We
Honor,
don't need
for
to,
the
you don't need to
record-
go over this on the record.
So the lawyer wants to not have anything recorded on the record, because if it's on the record, it goes in the transcript. And if it goes in the transcript, then everybody knows. He already spoke to him an hour before. He just was trying to ask the judge for an adjournment. And now the client is going back and forth with the lawyer in front. That doesn't look good either. So you can't really go back and forth with your lawyer in the courtroom either, because then the judge will stop it too. So he's trying to tell him, let's not talk about this now. And he's like, no, I want to talk about it now.
He's forgetting one little thing. It's called attorney-client privilege. And as long as it's not on the record, he can tell his lawyer whatever he wants. He can I robbed the stagecoach while he wants to. His lawyer cannot, tell on him because it's clients. Whatever he says stays between them two. He cannot be forced to repeat it in open court. So this is not a smart move right here.
Mr. Smith.
Mr. Drukas, for the record, should defense counsel address bond, I will be asking the court to increase the defendant's bond. I understand why Mr. Drukas is making the decision he's making.
Okay, I understand. When is my next court day?
So the DA, the district attorney, wants to have the bond
That's actually
increased.
ADA.
ADA, I'm sorry, wants to have the bond increased. If they keep talking about so that's why the lawyer's like, stop talking.
Something's going wrong because the ADA is like, if you go for this now, I want to raise.
I want the bond
increased.
But let's
And
keep going.
The attorney's like,
Let's keep
don't
going.
talk.
So are we done with the bond thing?
He ain't even address it.
Yes, Your Honor. I believe you had said November 9th.
Mr. Durkin,
Yes, Your Honor.
do you want to address bond? He wants to address bond.
No, Your Honor. I'm asking for that.
Is
So if you didn't hear this, rewind back. The ADA said, if we're going to discuss bond today, I'm going to want to increase the bond. And the judge, then they still going back, and then now the client is saying something about the bond. And the judge is like, oh, you want to talk about the bond today? And the lawyer for the client is like, no, I don't. But the client is like, yes, I do. Watch this.
See on November 9th.
Mr. Smith, the risk is if I address bond, I'm going to address all bond. I'm going to leave it where it is right now, but the people have made it clear that they're going to be asking for an increase. Your counsel is making a strategic decision not to address bond at this time, but if you wish bond be addressed, then
No,
So once again, the lawyer says, no, I don't want to address the bond. I want to postpone. He wants to postpone everything. He just wants to get this closed on the record. He wants to get it closed so he can go back and talk to him and try to figure out what's best for him.
Or there's some information that needs to come out, and
he's trying to get
right
everything
now,
together.
This is not the best move for us.
This is not the best move.
Unfortunately, for you to stay where you are and we
just
can
be quiet.
We can get
so
this
I can
resolved
talk to you
another
about
day.
this on the side.
Because he's already in jail and already the bond posted, and he can't get out. So if they ask him for an increase, that means they don't want him to leave the jail. When the ADAs ask for an increase in your bond, they don't want you coming out. They want you kept behind bars. So he needs to stop. He's not listening to his attorney. This is an example of not knowing what's good for you.
I did not want to postpone my preliminary. I wanted my preliminary.
So preliminary. He said it wrong so many times. I subconsciously can't say it together. A preliminary hearing
Yep.
means that's like the opening statements when they start talking about what's going on. This is where the lawyer will say things, like to the defense of their client or whatever. But here's the thing.
They want to have suppressed.
But here's the thing. The DA goes first, the defense goes second, and then the DA goes back again.
So right now you have had so far, his lawyer
has said to him several times,
stop
talking.
And the judge has kind of hinted so far,
stop talking.
I think you need to stop, and he's not getting the hint.
You want to go, we could go. May not work out for you.
I didn't want to post no more probable cause. I want to move towards the preliminary. I don't want to have another probable cause conference.
Your lawyer's going to get another one.
Again, it's amazing. This guy is sitting here. He's telling the judge dropped the hint. The judge said your lawyer is strategically telling you to not go through this hearing, this preliminary hearing. He don't want a probable cause hearing, which is the hearing to see if there's probable cause to continue an action against them.
To see if they have enough to bring charges against them. He wants to jump ahead to the judge making the decision.
The preliminary hearing is a suppression hearing. That's if they and
they
it's
want
suppressed,
to have a
thrown
video
out.
or this proof that could work against him. That so the lawyer's trying to say, listen, we need to look and see what's going on because there might be some things that may not be to your benefit. So that's why I want to adjourn until another
Because
day.
he has not had, he just got assigned the case yesterday. He has not had time to prepare the case. It's in his best interest to fall back, but you don't want to listen.
Have you
That's
looked
why
over
me and
all
my
of this?
attorney not even on the same page. Me and my attorney
Mr.
not even on the
Mr.
same page.
Smith?
Judge Simpson, don't do this
Mr.
to
Smith,
me.
did you listen to what your attorney said? There's video he still has to go through with you.
Yeah, but
So you want to have your preliminary examination before that happens? Because if I said it, I'm going to instruct the judge that not to adjourn it because you want to look at the video now.
To be clear for the record, the videos that we have turned over to defense counsel include the defendant brutally assaulting.
So now the DA,
That's not good.
That's not going to be good at all.
The judge said that the judge is very subtly giving him a hint. Your attorney has evidence to go over with you. And you need to go over the evidence to see what you want to exclude,
and what you
want
want
to include,
if you want to
what's
say,
going to make you look good and what's going to make you look bad. And now, according to the ADA, the evidence that they submitted so far to her is evidence that's going to make him look bad. He's not. He's
just not really thinking about it.
No,
I mean,
he's
again,
too
he
caught up
wants
in
to
his
have
head.
he wants to have his voice
wanting to
heard.
get released, but he's not thinking about the bigger picture and getting out. Period. It's ridiculous. You know, he's in his own head. He's in his own way. That's where he's on his own way from.
A victim. She was on the ground. He kicked her in the face repeatedly until she was left with what looked like a broken jaw to the police. She could not open her mouth and she could not speak, and she was rushed to the hospital. Defense counsel has requested an adjournment and requested that I look into whether there are additional videos leading up to the assault to help Mr. Smith explain to the court perhaps what happened leading up to that.
So now the ADA starts to explain what they have in the video that they have. That she's saying that in the video, he did all these things, but they're saying that they don't know why he did it. So they don't know if he was defending himself. They don't know if something happened before this happened. That this
and
was
she was asked to look into it.
And then she was asked to look into it to
see
find out if there's more
what
videos.
Events led to this? What events led to this brutal beating he gave
because
this woman?
he beat this person so bad that this allegedly that this person has a broken jaw. They couldn't even speak, and they went to the hospital.
Now this guy is fighting against himself also
because
the judge just gave him a hint. His lawyer said shut up, and now the ADA is saying, I was asked to look into evidence that's going to make you look better and maybe justify why this went to why this woman got behind beat. Maybe, or at least explain why this happened.
We don't know what happened
and you
before.
not look like a monster, a complete monster.
We don't know what happened before. So they're trying to find out what happened before.
I am more than happy to continue to a preliminary exam with the only evidence available.
She is more than happy because at the end of the day, it works to her benefit. Because now, look, if we just go by this thing,
the only evidence they have is the evidence
him
that makes
brutally
him look like a
attacking
monster.
this person, and we don't know why. We don't know. She could have thrown a rock at him right before the camera picked up or whatever, or another camera could have blanked out. We don't know what happened. Nobody knows what happened. But the only video they have right now is to say this is a preliminary. Woo! He got me messed up. Preliminary hearing to determine
all these factors,
all these other factors.
What could have caused this to happen? Should we go extenuating circumstances to lower the crime based on what we now know as an evidence and any mitigating circumstances?
Right.
But he doesn't want that. He wants to go with
because now what he doesn't realize he's doing is he's actually having his trial almost right now at this moment.
That's what he's trying to do. He's skipped the procedure. He's being a fool basically, and he's being very foolish. Again, he's the lawyer. He's his own lawyer. And he's being foolish now. He's not being.
Because this lawyer is like, stop it.
Being the brutal assault that this man committed on that woman. So, Your Honor, if we want to go to an exam, let's go. But I will not be getting those videos turned over before that exam date.
Hey, what do you folks want to do?
Break out room with my attorney, Your Honor?
No, I already said no.
So,
So you wanted that, you already spoke to your attorney. Your attorney had a very clear picture as to what he wanted to do. You come here this morning, I think changing things. And
Because me
I
and him
just
went-
want, if you want it set for an exam, I'll give you an exam. I'm assuming that setting it for an exam, Mr. Drukas, that would be over your advice to him at this point.
That is correct, Your Honor. Mr. Smith, let's proceed to November 9th and we'll continue to negotiate with the prosecutor.
no, I want to say it to the exam.
Okay, well, that's against my advice. Your Honor, you
Hughes,
can have an exam
Ms.
date.
Hughes,
Well, as part of his attorney telling him, let's move forward, let's adjourn this
Let's adjourn this.
until the next time, next
Because
time
they
come
have
back.
more video. The
we're more
ADA
prepared.
says she has more videos and she hasn't looked at them yet.
We can
She only has
explain-
the one video that doesn't make him look good.
Right,
She's
you-
trying to see if she can find a different video that might show it from a different perspective. Because let's think about it. 5 people on the street, they have 5 different viewpoints and they
Yeah,
might have seen something.
So what she's trying to do is she's trying to sit there and go into basically something that won't make you look as so much of a monster, like I said before, and that might even exonerate you from why or justify, because you have a right to defend yourself under certain parameters, outside of your home. And since this happened, outside, it could be resolved or explained at least with the video. A picture's worth 1,000 words.
ready to go to exam this Tuesday?
We will do everything we can to get the victim there. And hopefully,
All right.
given her injuries, she's able to speak at that point.
All right. Well, we'll figure it out at that
Now, can
point.
we address
But we'll start his exam.
Can we address?
We'll start his
bond?
exam October 31st,
Can we address?
2023, 9 a.m. That's before me. Oh, joy. All right. Mr. Drukas, I
Yes, Your
realize
Honor.
your client's pushing you over your advice. Do you want me to address bond?
No, Your Honor.
Mr. Smith, you want me to address bond
Please, Your Honor.
over your attorney's advice?
Yeah.
Okay, go ahead. Tell me what you want me to know.
Over his attorney's advice, he said, the judge says, do you want me to address the bond? He's like, yes. He asked the lawyer first. The lawyer says, no. And then he asked the guy, do you want him to address? And he's like, yes.
He is not.
He's not
No,
thinking
he's
about
not
it.
thinking about what he's saying.
And then I understand that he does have his mental issues or whatever, but he's not really thinking about what he's saying. And so what happens is that I don't know if he's trying to get the case thrown out or whatever, but it's not going to work the way he thinks it's going to work.
Yeah, he's a little reckless with his mouth right now, and wisdom has left him completely.
Your Honor, my name is Theophilus Smith. I'm paranoid schizophrenic type 1, 2, and 3, and bipolar type 1 and 2. I had a rough breaking up, Your Honor.
For those of you who didn't understand, what he said was he had a rough childhood.
He did not have the best of childhood. So, and he also has, he's bipolar 1, 2, and 3.
No, he's
paranoid schizophrenic.
1, 2, and 3.
1, 2, and 3. Excuse me.
He's bipolar 1 and 2.
He's bipolar 1 and 2, which means that there's a level that they use in So this is me on Google now. It says paranoia is a pattern of behavior where a person feels distrustful and suspicious of other people and acts accordingly. So he has a mental disorder that affects his ability to trust people or whatever, and he could act out because of that. Then he also has bipolar 1 and 2, which that is where it's not a milder form, it's a separate diagnosis. So he has 2 different diagnoses. So that means that he has with one, it could be a longer episode.
He has problems.
And he can have shorter episodes. So he has so depending on the situation, he could either have had a break, and then as a result he could have other things that can be ongoing.
I knew I should have called the law. I should have called the police when he was making all them.
I'm going to stop you right there, Mr. Smith. I don't want to go into the facts of this case.
No, I just let me talk, Drukas. Please let me talk. It's between me and the judge.
Well, you can't talk about the facts of the case.
Your Honor.
Mr. Smith.
Yes.
Just because you're going over the advice of counsel, I'm just going to advise you that anything you say can be used against you. You understand that?
Yes, Your Honor.
Okay. I've given you your warning and admonition. Go ahead.
So the judge said he's going to give him a warning and admonition. So admonition is, in the dictionary, is advice with a hint of scolding, a warning not to do something, like when you're cautioned or warned about some mistake you might be just about to make, or some looming danger, you're receiving an admonition.
Which is, he was admonished. That's that phrase comes. I admonished him.
So the judge is giving him a warning, an admonition, and he has it. Once again, all these things are going on the record. So the court reporter is typing all this stuff in while he's talking, and they're trying to back this guy off, but they keep trying to tell him, you got to stop. Even the judge is saying, you really want to talk about this?
I know it's a line and he's hungry, but he's my friend. I just want to
give him a hug.
I want to give him a hug, let him know food's coming, and he's taking. And he just told his own lawyer to shut up. Let him talk. Okay.
Okay, Your Honor. Well, pertaining to the case.
And I'm going to stop you right there again, Mr. Smith. I'd prefer that you not speak about this case.
But I'm asking you to address bond, and you're not doing nothing I want you to do. So let me do what I have to do for myself. This for me, not for you.
I know. And we talked about this. This is about
I know, but guess what? You not listening to nothing I'm saying. I would rather have Lamus represent me. Lamus. Because you're not doing nothing I said. And me and you we weren't even on the same page. We weren't even on the same page before the meeting ended earlier. So just let me talk without you objecting to your own client.
The lawyer is not objecting to him. And this is probably, I don't know if it's part of what's going on with him, but he's not realizing the lawyer is not objecting to him. The lawyer is objecting to him speaking right now at this moment, because whether he realizes or not, everything he's doing, he's taking a shovel and he's digging himself into his own hole.
Right.
And then he's taking a shovel and throwing it out the hole. So anything that he could do to assist him, he cannot, because he keeps talking. And the lawyer's like, listen, I don't know. I'm saying I don't know nothing about this case. I want to talk about this later. You said, oh, we already know what we need to know. The judge is saying, do we really? The the prosecutor said,
who wants to put him in jail is saying, no, don't say nothing.
Let's talk about this later. Yes, let's let this wait. He's like, no. Let's do it now. And then he's not realizing that let's do it now. Then later on, what's going to happen is later on, he's going to sit there and say, oh, they didn't take care of me the way I wanted to be taken care of. That's what you wanted.
You got what you wanted.
Can you let me
All right. Mr. Smith, you seem to know better. You go ahead.
Your Honor, the defendant made several death threats to me. Not the defendant, the accuser. I don't know how the accuser knocked on my apartment door.
And again, Mr. Smith, I'm going to reiterate that you should not be speaking about the facts of this case.
Okay, I'm not going to speak about the facts of the case.
Okay, thank you.
Your Honor, if you could please give me a personal reconduct bond. Your Honor, I'm not a flight risk. I'm going to be in court on Tuesday. If you can lower my bond or give me a PR, Your Honor, I won't speak about no more of the facts of the case until Tuesday. I'm going to respect Edward Drukas on that point, that I won't speak on the case. But if you could just give me a PR bond or lower my bond, because my family is not wealthy, Your Honor. We are not wealthy, and I can't afford $50,000, no 10%. Your Honor, if you can please just give me a chance to give me a real lawyer. Give me a lawyer. Give
A
me
real lawyer?
no, a lawyer. No, I don't mean. I'm not taking nothing away from Jukas. I'm not taking nothing away from
Okay.
Jukas, Your Honor. I just want to check.
Oh, okay.
I just want to be free, Your Honor, because I feel like I'm not even guilty of this. My grandfather got inside of me.
So I think this was the outburst that the lawyer was trying to avoid. This is why, because remember the lawyer said in the beginning.
Say, hey, buddy, I gotta get in you right now. Because you're in jail, I gotta get in you.
Did he get in him when he was in jail or before? Maybe his grandfather's the one who hit the guy.
I don't know.
Because you know they made him stronger back then.
Yeah.
They made him stronger back then.
I don't know. I don't understand that one.
But this is probably why, because in the beginning, if you remember in the beginning, he said he spoke to him for 50 minutes. It's almost an hour. So he was trying to tell the judge, I didn't even get to speak to him for an entire hour. And, you called the case. So this is why I want to adjourn it.
But his
client
is saying, I don't care what you want to do.
I want a real lawyer.
I want a real lawyer.
And then he said, then he doubled back again. I want to be free, and I want a personal recognizance bond, and he wants all this stuff. But they're telling him,
you need to wait so we can get a proper hearing to get you out of there. But that's not what you want. Okay, you got it.
My grandfather was talking to me. My grandfather.
Ms. Hughes, response to the motion to reduce bond.
Thank you, Your Honor.
Mr. Smith, before you go, Ms. Hughes, Mr. Smith,
yes,
I warned you. I told your counsel that if you ask me to address bond, I'm going to address the whole thing. So maybe when Ms. Hughes gets done, I haven't made a decision yet, but maybe when Ms. Hughes gets done, this bond goes up. I gave you that warning and you went ahead. So now I'm going to let the people give their version. Go ahead, Ms. Hughes.
Thank you, Your Honor. The people are requesting that this court set bond in the amount of $250 cash only.
The bond is now 5 times the amount it first was. First, it was $50,000. He was trying to, and
now she's requesting to be $250,000, $250,000.
Notably here, the defendant's bond is $50,000 cash only. This is not even a cash surety case, never mind a 10%, which I think is pretty telling given how unique that type of bond is. The defendant is on misdemeanor probation for use of cocaine. It was initially charged as possession of cocaine, and it was pled down to use. At the time of his arraignment in this case, he was already in violation status of his misdemeanor probation. The defendant has a criminal history dating back, as far as I can see, to 2000, which includes a number of drug and alcohol misdemeanor offenses. He also has 6 assaultive felony convictions. In 2014, he was convicted of a couple of cases of R&O on the police. In 2019, he was convicted of felonious assault and CCW.
So now, not only are they using that videotape of him brutally assaulting someone, now his criminal history, which can be used against him.
Since he want to talk about it, now she's pulling everything out, and she can use whatever tactics she want to use.
He has 6 felonious assaults. I mean, he hurt 6 times. He assaulted someone and hurt them bad. When it's felony weight, you got jacked up bad. Which
means he could do it. He did at least a year today.
And R&O means he was resisting arrest and obstructing the police officers.
And he was on he was on misdemeanor probation and for possession of a illegal substance.
Right. And
they fled that down.
He's carrying a concealed weapon. And the R&O makes you even more graver danger because of the fact that if you will sit there and resist a police officer and obstruct them, you're a greater danger to the regular community at large because you're straight up resisting any lawful authority.
In this case, this occurred in Miller Manor inside the apartment building, and the apartment building has cameras in the hallway. This case came to the police attention because a neighbor in Miller Manor heard yelling in a hallway. He exited his apartment, went into the hallway, and saw the defendant standing over a woman who had been brutally beat. She was laying on the apartment hallway floor, unable to get away from the defendant. The defendant then fled, went into his apartment. When the police arrived, they first tried to make contact with the defendant. He refused to open the door, refused to provide his name, refused to cooperate with the police. When the police made contact with the victim, her face was so damaged that she could not speak. She could not open her mouth. The police tried to interview her, and she could not even remain conscious. They were able to get her to agree to a medical release, and by the time they presented the medical release to her, she was no longer conscious to be able to sign it. The report indicates that she had injuries to her nose, to her cheeks, and to her jaw. She was immediately rushed to U of M. I am still waiting on her medical records to determine the extent of her injuries, but based on the police report, the police believe that her jaw was in fact broken, which is why her face was swollen and she was unable to speak. Again, Your Honor, our request is $250 cash only.
That is a lot to unpack. So the only evidence we have is the evidence showing that you are a monster. The witnesses that they have right now, do you bring into account, since you want to go this way, say, hey, I saw him staying with a woman who was beaten. They said that, again, not talking to the police, not answering your door, that's obstructing and resisting right there.
So, unfortunately, what's going on now is that here's what happened. Basically,
what happened was
they just had a trial almost, because
yes.
when he said he didn't want to stop talking, when the lawyer said they didn't want to stop talking, when he started talking about the facts of what happened, because once again, during the trial, this is just based on my Law and Order experience, and in the episode, in the middle of the episode towards the end, that's when they have the trial.
I'll confirm.
And they'll say the DA will present the evidence, and
Yes.
the DA will say, we're here today about this, and then the defense will say, well, this is what my defendant, this is what the defendant says happened, and then the DA will come back and they do what's called a summation, which they summarize the story or whatever. So once he said he wanted to talk about the facts in the case, and it was between him and the judge, and the lawyer had to stay out of it, and the lawyer's like, I really don't want to stay out of it. But he sat there and almost basically had a small trial, and now they upped his bond. So now he talked himself for $50,000 that maybe they could have did a 10%, which would have been $5,000 surety bond. Now now it's at $250,000.
Everyone advised. No, he didn't. He's about to say it. Everyone. He said they want $250,000.
They want $250,000.
He told them to be quiet.
He kept telling them to be quiet. Let's deal with this later. Let's deal with this later.
The DA who's trying to convict him said be quiet. Everyone said be quiet and wait for the evidence to come out showing that you're not a complete monster. There might have been mitigating circumstances to show why this happened. Not justify it, but to show maybe what led up to this, which might seem reasonable. Oh, that's what happened? Okay, well, in light of this evidence,
like we said earlier, we don't know what actually happened before, because they went to the video camera. Like, once again, she only has one tape, so she's saying, well, okay, so this one tape happened between, say, 1 and 2. So what happened between 12 and 1? What happened before that? So that's what they want to know. They want to know what happened before that.
So basically, everyone's trying to say, listen, don't stick your head in the noose. Wait for the trial first, and then if you get convicted, you get hung. No, I'm not sticking my head in this right now. Okay, let's see how this works out.
Anything else from the defense?
I think enough has been said, Your Honor. Nothing further.
Court believes, and the court would find that the setting of under the circumstances of this case, that, and with all due respect to the magistrate, I understand what they were going through at the time, that the bond that is set at that time, court would find that under the circumstances of this case, that may have been an abuse of discretion. The court will increase the defendant's bond in this matter, finding that the defendant is a risk to the public. Well, a clear danger to the public given the circumstances of what the court has heard. Defendant's bond is increased in the amount of 2,000 or 200,000 cash surety. Thank you.
I'll come and see you, Mr. Smith.
Thank you, Your Honor.
Well, I guess it's no surprise how this was going to turn out. This is a surefire way of an example of when they say a man that acts as his own attorney has a fool for the client.
Well, this is the perfect explanation of you have the right to remain silent.
Yes.
And the Miranda rights are as follows.
You have a right to remain silent.
And
Anything you say can and will be used against you in the court of law.
And
You have a
so,
right to an attorney. If you don't have one will be appointed for you. Now that we've read these rights to you, do you have anything you'd like to say? And that's the best time to shut up. But he's in court already. He's in jail already. And he has a lawyer already. And he still wouldn't be quiet.
but the lawyer said, we don't want to talk about it. Let's talk about it later.
No, I don't know.
I guess, I don't know.
If there's a chance of my client getting out on the 9th, I'd rather wait till the 9th and perhaps maybe he can get bail on the 9th. Maybe his bail will stay at 50,000 and perhaps
And we
he
can
can
get a
even
10% surety.
there's a slim chance because based on what we have, he'll get out of jail because based on what they have and the only piece of evidence that they had today, there's no way he's getting out of there.
Thanks for watching.
And also give us a thumbs up, like, comment, share. Subscribe to the channel and you'll be notified of every video as they come up. And get that algorithm going and help us build this channel in 2024.
And make sure that you don't wind up in a what had happened situation.